hear a lot about the term or the catchword, international law, thrown out there, and automatically we kind of assume this defensive posture, or let's talk about something else. Almost as though we've acquiesced and assumed that there's another side that is more right, more just. We are very fortunate to have somebody who can authoritatively address this topic and effectively. Professor Eugene Kontorovich teaches at Northwestern University School of Law, and he's the head of the International Law Department at the Kohelet Policy Forum. I'm also going to butcher his bio. Please forgive me, Eugene, because again, otherwise there will not be time for you to speak. He has served as a consultant for the U.S. Defense Department and wrote a Supreme Court amicus brief in the Jerusalem passport case. His scholarship has been cited in leading international law cases in the U.S. and abroad. He also plays a leading role when it comes to drafting laws about Israel boycotts in the U.S. states. He's testified repeatedly in Congress about the Arab-Israeli conflict and regularly briefs visiting European and American legislators, celebrities, journalists, etc. He's been honored with the fellowship of the Institute for Advanced Study in Princeton in 2011-2012, and with the Federalist Society's prestigious Bator, whichever, award given annually to a young scholar under 40 for outstanding scholarship and teaching. Without further ado, Professor Eugene Kontorovich.
I'm a professor of international law, and the points I'm going to briefly make are based on my research, based on my academic work. It's very hard for a professor to speak in 1 hour, let alone 10 minutes, but it's completely appropriate because the context in which next year we're going to have to be answering these questions, when everyone's going to be saying illegal occupation, even more than they are now, the context we'll find ourselves in is one in which one has to make a very quick response. And no one is going to listen to an hour-long presentation. Nonetheless, much of what I say, if you are interested in, there's scholarship behind, there are papers and extensive written evidence to support, which I could provide. So next year, the central argument is going to be 50 years of occupation. And it's hard to confront because we're not in the habit of doing it. We're in the habit of conceding it and saying, but we have historic ties, but it would be dangerous otherwise. We are, as Avi mentioned, uncomfortable on the legal ground, but we should be comfortable, and we should get comfortable, and indeed we should actually welcome this opportunity. And before I get into the specifics, it's important to understand the methodology of international law. This is something people don't understand, and it's absolutely necessary. The rule of international law that governs any situation is not what the UN has said about that situation before. Like when you have a case in court, the rule that the court has to apply to that case doesn't come from the case itself. Where does it come from? Other cases, precedent. So you cannot understand about international law as it relates to us unless you look around the world. And it's extremely important for us to always ask the question, when someone makes a claim about Israel and international law, you're not allowed to have your people live in this place. For example, take that claim. Say, can you show me somewhere else in the world where a country was forbidden from letting its people live in a place where its sovereignty was disputed? Show me an example. Show me one country that said to its citizens, we're going to keep you from living here. Show me a place where the international community required it. Show me a place where a country did it. And there are many disputes around the world, territorial disputes. That's never happened. That's never happened. And just to anticipate the objection, this isn't changing the subject. Some people say, oh, you're trying to change the subject. No, if the subject is not the Jewish people's historic rights, not the security of the Jewish people, but if it's the international legal rules, looking internationally isn't changing the subject, that's the subject. And a discussion of international law that's not willing to engage on those terms should take away from itself the appellation international. Okay, so 1967, what's the deal as a matter of international law? Israel takes control of Yesha. How do we relate to that as a matter of international law? And we have to first understand what's the status of Yesha. What's the status of these territories? So for that we have to go back to 1948, the birth of the State of Israel. Israel was created in 1948 at the conclusion of the British Mandate. and we're actually on pretty solid ground here. Because everyone agrees what the borders of the British mandate were, mandatory Palestine. Everyone agrees. Not an area of uncertainty. So the mandate ends, State of Israel is created. What are the borders of the State of Israel? How do we figure that out? Well, let's ask ourselves the question. How do we figure out the borders of any new country? This is not an exotic situation, the creation of a new country. As a matter of fact, all the countries around us are fairly new. Jordan is new, and Syria is new, and Lebanon is new, and Iraq is new, and there are a lot more newer countries. So there's a basic rule of international law. Very few things are as fundamental in international law. It's called uti potestatis juris, but that's a mouthful. There's a rule of international law for determining the borders of new countries. It's a fairly frequent situation. When you have a new country, what are its borders? It is not the case that you have to go back to first principles of justice to determine each border, each inch of each border of a new country. Otherwise, there would be constant war every time there's a new country. So the Soviet Union falls apart. 16 new countries are created. Yugoslavia falls apart. 5 new countries are created. The Czechoslovakia splits. The Ethiopian Empire splits. These are all very recent things. In each case, we have a very good understanding of the borders of the relevant countries, based on this principle. And what's the principle? When a new country is created in a territory that formerly did not have self-rule, be it colonial, be it a mandate, be it an empire, be it a federal state, the borders of the new country are the borders of the top-level previous administrative unit, which in this case is the mandate of Palestine. And this works every time. What's the border of Ukraine? Borders of the Ukrainian Socialist Republic. What's the border of Croatia? Border of the Croatian federal unit in Yugoslavia. What's the border of, Eritrea? The border of the Eritrean subdivision of the former Ethiopian Empire. And what's important is this principle trumps everything else. It trumps claims of ethnic self-determination. Why? Because we always have those. Because all of these borders are not drawn based on tribal or national connections. These are by definition imperial or colonial borders most of the time. But nonetheless, the international community says we have to go by this rule, because if every time you try to create a new fair border for a country, you're going to have constant war. Constant war. Let me give you an example. And this rule, and this is the powerful thing about this point, show me another case where the borders of a new country are not the borders of the previous administrative unit. It doesn't happen. This is a special thing made up just for us. Take a recent example. Take, for example, Crimea, as Vladimir Putin recently did. The international community is convinced. They say for sure. The UN even said, we don't recognize Russian control. It's an occupation. Is that because the people there are mostly Ukrainian? So it's like an ethnic self-determination thing? No. Well, here they want to say that Yesha should be Arab because most of the people there are. So most of the people there, I guess, would be Ukrainian? No. Most of them are Russian. Is it that they're maybe linguistically or religiously more Ukrainian, even though they're more Ukrainian, even though they're ethnically Russian? No. They're like linguistically and religiously Russian. Is it that most of them want to be part of Ukraine? No, most of them probably want to be part of Russia. Not like the 95% from the referendum, but probably most. Is it that it has always been part of Ukraine? No, as a matter of fact, almost never. What's the deal? It was always part of Russia. In 1954, when both the Russian Soviet Socialist Republic and the Ukrainian Soviet Socialist Republic were part of the Soviet Union, so it didn't really matter. Nikita Khrushchev moved Crimea into the administrative control of the Ukrainian Soviet Socialist Republic. So it was part of the Ukrainian Socialist Republic from 1954. The moment Ukraine becomes independent, 1990, what are its borders? Well, the borders of the Ukrainian Soviet Socialist Republic, which now includes Crimea and all of the millions of Russians who happen to find themselves there simply because of a totalitarian dictatorial decision by Nikita Khrushchev. Is that legitimate? Is that fair? I'm not defending the Russian annexation, by the way. My point is, the rules of international law are blind to the equities, and they say, no, if that was the border of the Ukrainian Soviet Socialist Republic at the moment of independence, those are the borders. Period. And you can look at all the other League of Nations mandates. It is not a novel thing to have questions of arguments for partition or division of mandates based on ethnic claims. They had this in Iraq. There was an idea of having a Kurdish state in the north. They had this in Syria. They had this in Togoland. They had this in Cameroon. Everywhere, Doesn't matter whether there was discussion of partition during the existence of the mandate. If it didn't happen, the borders are the birthday borders. And that's an international law term, birthday, the birthday moment of independence. So when Israel takes the West Bank and Gaza, what is its status? Israeli sovereign territory that was occupied by Jordan for 19 years. Does the Jordanian occupation change anything? It would be very strange. Ask these international law people, ask your debaters, so are we like starting the stopwatch now, and if Putin holds on to Ukraine for another 15 years, you'll say it's his? No one's going to concede to that principle. So it's Israeli sovereign territory. Okay, but let's say it's not Israeli sovereign territory. Let's say it's like really complicated and it's unclear because Israel never controlled the territory. I can give you other examples to help bolster this. Azerbaijan and Armenia. There's many strong precedents. But let's say you want to say it's not really clear that it's Israeli. Well, it's definitely not Jordanian either. So what's an occupation? Occupation is a term of international law. It has no moral existence. It's a technical term. It's a situation when an army takes control of the territory of another state during a war. It's about war. It's from the Geneva Conventions. It's not illegal. Occupation is not illegal. It's a situation. It's a legal situation, which is neither legal, which is legal. But what's occupation? When you take the territory of another country, the Geneva Convention says occupation occurs during the occupation of the territory of another country. And international precedent supports that. So there's a strong argument, which Israel has made in the past, that if this territory wasn't Jordanian, then it's not an occupation. You can't occupy territory that's nobody's. So what is it? A dispute. That's why they call Kashmir a disputed territory, because no one knows who it was first. That's why they call the Korean Peninsula, where you have two countries claiming 100% of the same territory, a dispute, because no one knows who it was first. Okay. But the international community doesn't want to say that. They want to say, well, we're going to read the Geneva Convention very broadly, and it was Jordan's enough. It wasn't really Jordan's, but it was Jordan's enough that the existence of a state of war, which is what triggers the applicability of the Geneva Convention. You can't have an occupation without an international war. Right? You need an international war, and that triggers it, and it was Jordan's enough to trigger the provisions on occupation. Great. Let's even take that. We can work with that. That's actually maybe the best. That's the clearest. So let's say it was Jordan, enough to trigger the Geneva Convention. Fantastic, we signed a peace treaty with Jordan in 1994. And peace treaties everywhere and always terminate the applicability of the Geneva Convention. The Geneva Convention is a treaty about war. Its provisions on occupation continue after the end of active hostilities until there's a peace treaty. So if it was Jordan, if it's considered regulated by the Geneva Conventions because of Jordanian control, if Jordanian control is enough to kick off the Geneva Conventions, then Jordanian peace should end it. Find me another case in the world where the Geneva Conventions has been applied in any way beyond a peace treaty. Even coercive peace treaties, which are the normal kind. Never happens. So you're asking, so this isn't international law. This is not international law. If it doesn't happen anywhere else, and there's plenty of occupations around the world. So let me review. There's three options. Either this territory was Israel's because of the normal rule about the international borders, in which case Israel was just taking territory that belongs to it. What about the fact that it's under military rule? That shouldn't bother us. There's entire countries that are under military rule for like ever. Like Turkey for decades and probably soon again, and Colombia. The military government is just a form of government. It does not determine the sovereign nature of a territory. So either it's Israel's, in which case they just got back what was theirs, or it's not clear whose it is, and it's kind of a toss-up, in which case we don't say occupation, see Kashmir and Korea. Or it's Jordan's, and that actually triggers the Geneva Convention. Mazel tov, we signed a peace treaty which ends all claims of occupation. You might want to say Israel, and you have to say to people, maybe what you're trying to say is it's not good that Israel has a presence there, as a policy matter. Okay, so then there should be, if it's a policy issue, there should be a policy resolution. In the normal way these things are resolved. But there's nothing illegal. It's not a crime. And the baseline should not be the admission of the illegitimacy of Israeli action. Let me address then finally another point. Well, what about the settlements? So the important point about the settlements, the argument about the illegality of settlements is parasitic on the occupation one. You can only have, what they're talking about with settlements can only be a legal problem, even in theory, if there is an occupation. So since I think no matter whether it was Israel's or whether it was nobody's or whether it was Jordan's, there could not now legally be an occupation. But let's say there is. Option number 4. The world doesn't make sense, we'll call it an occupation anyway. Okay, it's important to know what they're talking about. The notion of settlements is not a word that's used in international law. The discussion is about one sentence in one provision of the Geneva Convention, Article 49.6. The occupying power shall not deport or transfer its civilian population into the territory it occupies. I personally do not know anyone who has been deported or transferred. As a matter of fact, if you look at the population of Yesha, it is extremely young. Well, what's the average age? 18, 19? It's very young.
Who's that?
Because people have a lot of kids. Most of the people were born there. Even our friends, the Human Rights Council of the UN, agree that the children of settlers born in an occupied territory are not themselves settlers. They don't say that about, they agree in the case of at least Turkey and Northern Cyprus. There they have for sure said that children of settlers are not themselves settlers. So presumably it would be the same rules. And the UK Parliament also says the same thing. So nobody knows what this rule means because it has never been applied to anyone except Israel. And here's the, I think, basic talking point. No country has ever been told to prohibit, inhibit, or obstruct the movement of its civilians into occupied territory. It's just never happened. Now, have countries allowed their citizens to move into occupied territory? Have they even moved them? Yeah, I can give you lots of examples. Even today. Turkey, a NATO member, into Cyprus, an EU member. Morocco, major recipient of American aid, into Western Sahara. Even in cases where people say, look, it's not a great thing you're doing. It's never called illegal. It's never denounced by the UN as illegal. And in no case do people say there's an expectation that you have to prevent your nationals from moving into this territory. So America occupies Afghanistan in 2003. You would expect, having told Israel so often that you have to make sure that your people don't enter this territory until there's peace, America would have taken prophylactic measures to ensure that U.S. citizens do not move to Afghanistan. Just to be sure. Like already, immediately from the Defense Department General Counsel, a memo saying, now that you're occupying, here are the things you have to do, no Americans. The opposite. America goes around looking for American citizens of Afghan descent to encourage to move to Afghanistan. It turned out to be a hard sell, so that there could be more Western-oriented people managing the banks and the airlines and the businesses. And indeed, people did move. Did anyone even suggest? I'm a law professor, and I can tell you, all the good ideas are taken. So most of our job we have to publish is to come up with, not good ideas. So any idea that is not certifiably insane, a law professor will write up into an article. Did anyone write up an article saying America should at least consider its potential liability under the Geneva Convention if it does not prevent its citizens from moving to Afghanistan? I bet you can say, well, there are Afghans, they're from Afghanistan. Great. We're Jews, we're from Judea. Same thing. Never been applied. And that's we can go into lots of technicalities about what the words mean, deport, transfer, etc. Basic talking, can someone born in a place have been deported or transferred there? It seems hard to understand. Never, and it's a rule that's never, now you can say, just because everyone else is breaking the rules doesn't mean we are. No, it's not that they're breaking them. The UN, no committee of the UN has ever said, guys, don't do that. And you can say, well, maybe it's politics. It really does not take much for a committee of the UN to ask people to do things. They complain about everyone all the time, actually. Not as much as us, but they criticize people for things they think they're doing wrong, countries. Never been said. So this is not a rule about international law, it's a rule about the presence of Jews in Judea, which, okay, that may be an ethically defensible rule or not, that's an entire separate discussion, it would seem hard to me, but already it's not a legal one. Now, I'm actually a little bit excited about 2017, if we can get our game together, because the biggest argument I encounter, two main arguments I encounter, I already addressed if everyone else is doing it, does that mean it's okay? I think we have very good answers to that. One of the biggest arguments I encounter is, well, okay, what you say sounds like it makes sense and it seems convincing, but the world's already agreed that it's not true. The world's already agreed. Okay, I love this argument because it really concedes a lot, and I hear it all the time. The world's agreed it's true. So first of all, one of the reasons the world's agreed it's true is because we haven't started making it. Palestinians were arguing their case for self-determination for 30 years before they got taken seriously as anything but a terrorist movement. but they were persistent. But also, I think, to the extent that you are interested in talking to millennials, and if there is such a thing as millennials, and if we should care about them, I think the argument, so we should accept something which doesn't make sense and doesn't really work elsewhere, anywhere else, and is inconsistent with everything else, just based on authority, because everyone says it's true. That's what you're going to base your argument on. That seems to me, from what people say about millennials, which I don't believe any of it. It's all marketing, and there's no reason to believe that people born around the same time or anything like each other. But assuming that there is this, to say, so you're accepting something based on authority, and if everyone, in 1950, if everyone said blacks are inferior, you'd accept that. That's like a form of argument that we accept now. And I think that's the kind of thing that at least millennials don't maybe want to accept. I'm happy to take questions.
Actually,
We're done.